You lose a claim at the Supreme Court so you can just slip into different ones instead? That's exactly the fight happening in the OpenAI case, and Microsoft is having none of it. We're talking about the Supreme Court's Cox decision. It completely wiped out one of the plaintiff's counts. They're now asking the court to let them add in two entirely different ones, specifically to conform with Cox, after fact discovery is over and we're barreling towards summary judgment. Microsoft says that's not complying with Cox, that's trying to rewrite the lawsuit. They're going to tear it apart, so stick with me as we look at yet more fallout from the Supreme Court's Cox decision. Oh yeah, they wanted to do a third amended complaint, and this one is really just butthurt because they lost one of their counts because of Cox. And most of this is basically the same. We'll just take a quick look at what's changed. I'm not really sure of everything that's changed because we don't have a red line, but we've got the ones that are relevant for this controversy. And I mean, it starts off with the usual whining. We're the greatest journalists in the world and they stole our stuff, and now they're going to ruin journalism and all sorts of mean, nasty, ugly things. But in the interest of not wasting time and getting right down to business, let's go straight to page 64 of the PDF file. So we're looking here at the different counts. We've got count 1, which is copyright infringement. By building training datasets containing millions of copies of Times works, including by scraping copyrighted Times works from the Times' websites and reproducing such from third-party datasets, the OpenAI defendants have directly infringed the Times' exclusive rights in its copyrighted works by storing, processing, and reproducing the training datasets containing millions of copies of Times works to train the GPT models on Microsoft's supercomputing platform. Microsoft and the OpenAI defendants have jointly infringed the Times' exclusive rights in its copyrighted works. This was all there before, and all of this is what was found to be fair use by two other federal courts, the only other courts to weigh in on it so far. They both found this was fair use. That's the one that definitely needs to go. So they've got count 2, which is vicarious copyright infringement, which says not only did they do all that, they profited from it too. Ooh, that evil profit. Now, count 3 is where we're going to get into this. Count 3 is contributory copyright infringement. And just to remind you what the Supreme Court said in Cox, they said that there is no contributory infringement if you're merely aware that sometimes people are going to use your product for infringing purposes. You have to either be a participant or directly induce the infringing, or you have to have a service tailor-made for infringing. In other words, one that does not have substantial non-infringing uses. So here's what they're saying now. Microsoft contributed to OpenAI's infringement by intentionally inducing OpenAI's copyright infringement and providing OpenAI with tools tailored to infringement. See what they're doing? See how they're slipping Cox in there? Microsoft intentionally induced OpenAI's infringement by actively encouraging OpenAI's infringement through specific acts. Microsoft provided this service to facilitate OpenAI's copyright infringement by providing it with access to copyrighted works and curated its platform to disproportionately feature the Times' works to train OpenAI's LLMs. The principal object of these services was to download copyrighted works, including those belonging to the Times, provide OpenAI with direct copies of those copyrighted works, and ultimately use those copyrighted works to train and fine-tune OpenAI's LLMs. You see how they're begging the question here? If all of that is fair use, then the rest of this should fall like a house of cards, but because they're using the magic phrases from Cox, intentionally inducing and tailored to infringement, they're trying to bypass all that. And they continue on the next page. Microsoft also provided OpenAI with services tailored to infringement. In addition, Microsoft's supercomputing platform was tailored to infringe copyrighted works, as it was specifically designed for the purpose of using the whole internet, curated to disproportionately feature Times works to train and fine-tune OpenAI's models. Microsoft's supercomputing system does not otherwise have a substantial or commercially significant non-infringing use. Now that's not really what you're supposed to do in light of Cox. Cox means you delete. You don't get to add on. You don't get a do-over. And you see, that's what happened with count 4, contributory copyright infringement, dismissed. That went away because of Cox. And then count 5 is the CMI stuff. We've covered that in so many other videos. Count 6, common law unfair competition, was dismissed. And count 7, trademark dilution, dismissed. That one deserved to go away too. Alright, so you see what's left. They didn't have much that was left. The only count that should have remained was that first one, the one that I said has already been found to be fair use by other courts. And apparently they didn't want to rest on that, so they had to slip in those other two. Well, of course, Microsoft is going to feel some kind of way about this. Here we are with their memorandum of law in opposition to all of this. So let's get into it. The New York Times Company and Daily News Plaintiffs, together News Plaintiffs, claim that their proposed amendment is merely an effort to conform their pleadings to Cox, which forecloses their current contributory infringement claim against Microsoft. It is plain on the face of the proposed amendment that this is not the case. Rather than simply withdrawing the claim or tweaking its contours, News Plaintiffs seek to add brand new inducement and tailored-to-infringement claims that were long available to them. As News Plaintiffs themselves concede, Cox did not create or in any way alter these theories they now wish to assert. It simply foreclosed the material contribution theory they chose to pursue throughout fact and expert discovery. Cox didn't contribute the whole tailored to infringe and all of the other stuff. That was already there. They just said if you're going to do that, that's the only ones left, not just knowing about it. Nor can News Plaintiffs point to newly discovered evidence to support amendment. The materials on which they rely have been in their possession for over a year, and in most instances, nearly 2 years. The time to amend has long passed, and Rule 16 demands diligence before permitting an amendment. The new claims would substantially alter the landscape in multiple ways. They focus on later models and products, and Judge Wang already said you can't do that. The tailored-to-infringement claim is an inherent assertion of product design and functionality that was not evaluated, tested, or opined about in Microsoft's expert reports. And the new inducement theory requires discovery into specific intent to infringe, which implicates an additional set of witnesses from the ones who were deposed during fact discovery. Permitting News Plaintiffs to amend their complaints at this late stage would be unfairly prejudicial. News Plaintiffs cannot establish the good cause Rule 16 requires and weighed against the obvious prejudice, their motion should be denied. News Plaintiffs' motions seek to assert theories that were available from the outset based on factual material they had obtained long before discovery closed. They cannot meet Rule 16's demanding good cause standard. Because if something new had come up during all this, that would be understandable. They would say, hey, there's this new evidence. Now we need to amend it. But that's not what happened. Something new did come up, and it was Cox. But as Microsoft says, Cox does not provide good cause to add well-established inducement or tailored-to-infringement theories. From the outset of this case, News Plaintiffs elected to pursue against Microsoft only the material contribution variety of contributory infringement. Although the other two recognized variants, inducement and tailored-to-infringement, were available to them, News Plaintiffs never asserted them. In fact, the Times' own counsel represented to the court that its claim was not contributory infringement by inducement, and reiterated that it did not have a claim by inducement. With this in mind, News Plaintiffs' reliance on Cox as an intervening change in controlling law is puzzling. The only relevant way in which Cox changed the governing law is that it rejected material contribution as an independent basis for contributory liability. That is why News Plaintiffs have properly withdrawn count 4 of their complaints and why they delete the words material contribution from the count they here seek to amend. But that development does not explain, much less excuse, News Plaintiffs' reliance on Cox to justify their 11th hour strategic decision to switch theories. Inducement has been a viable theory of contributory copyright liability for decades. That was back in Grokster. News Plaintiffs themselves identify inducement as one of 3 recognized theories that existed before Cox. That concession alone undercuts any argument that Cox suddenly supplied a theory News Plaintiffs could not previously have pleaded. Also available all along was News Plaintiffs' new alternative contention that Microsoft supplied services purportedly tailored to infringement. News plaintiffs concede that this theory, too, was recognized before Cox. However news plaintiffs chose to label their proposed amendment, every affirmative theory they now seek to add was available well before Cox, and for that matter, well before either plaintiff filed its complaint. Grokster was in 2005. Cox therefore did not create some modified standard to which news plaintiffs need to conform. It killed the claim they chose to plead and press through discovery. News plaintiffs cannot transform the loss of their material contribution theory into an opportunity to add a different theory long after the amendment deadline is passed. The depositions on which they rely were completed in February, the last being on February 4. News plaintiffs therefore had that testimony more than 4 months before filing their motions, and critically, while fact discovery remained open through February 27. If news plaintiffs believed the testimony furnished a basis for a different contributory infringement theory, Rule 16 required them to seek leave promptly to amend their complaints. Instead, they waited until fact discovery closed and expert discovery was well underway, and the summary judgment briefing was swiftly approaching. Plaintiffs' failure to act is precisely the kind of delay that Rule 16's diligence requirement is designed to prevent. And the prejudice here is substantial. Fact discovery has been closed for months. 3 rounds of expert reports have all been served, and expert discovery closes on August 3rd, and opening summary judgment briefs are due a month later. Allowing plaintiffs to alter the central theory of Microsoft's alleged contributory liability at this late stage would deny Microsoft a fair opportunity to defend against brand new claims. The proposed theories are not new labels for the claim news plaintiffs have already pleaded. They are different claims requiring proof of different facts. And as a matter of fact, the Times expressly represented to the court that it was not pursuing an inducement theory. And now they are all of a sudden, because Cox is inconvenient for them. The court should deny plaintiffs' motions. Plaintiffs waited until the 11th hour to advance theories they could have pleaded at the outset. They have offered no adequate justification for their delay, and the risk of prejudice to Microsoft is concrete. Fact discovery is closed, expert discovery is nearly complete, and summary judgment briefing is imminent. Granting leave now would require Microsoft to defend against fundamentally new claims without the opportunity to develop a record on the facts those claims demand. Sounds to me like that should be a slam dunk, but this is the SDNY. We've definitely seen that Judge Wang is no friend to them, but Judge Stein has smacked her down a time or two, so maybe Stein's better on this. In any case, it's completely clear that Cox does not allow this. But we're going to see this kind of legal maneuvering, I think, in even more cases as it goes on down the line, because Cox is so inconvenient to the big copyright cartels. It took away one of their biggest weapons to use, and it has been glorious. So we'll see if the court lets them get away with it. Of course, I'll be here to let you know, so please hit that subscribe button, and of course, comments for the comment god, shares for the share throne. Hit like and the bell as well, and if you're on mobile, swipe left a couple of times and hit that hype button. All of that gets me up in the algorithms, and of course, donate.pagosity.tv to keep me doing what I do. You can make one-time donations or regular support through Patreon, Subscribestar, or Discord, so please check all of that out. Thank you so very much for watching. Until next time, stay strong and be free.